My name's Kelly Lance. I'm the event coordinator here at St. Leonard. I want to welcome everyone to our second Public and Political Issues Workshop. We thank you for being here. Over the next 2 years, St. Leonard will host 6 more workshops leading up to the election in 2024. These workshops are offered as a public service to inform and engage citizens. These workshops are supported by the University of Dayton Special Programs and Continuing Education through its Osher Lifelong Learning Institute, UDOLI, and by the Friends of UD here at St. Leonard. Before we get started, I do want to thank a few people. Julie Mitchell is here. Julie, if you'll just stand up. She's the, Julie is the Executive Director of Special Programs and Continuing Education for the University of Dayton. So we thank her for sponsoring and supporting these events. We could not have done this without you, Julie. Thank you. And then we have our Friends of UD committee here at St. Leonard. They're around the room if they just want to raise their hands. And Bob's running the camera. Thank you to all of you. And of course, we want to thank Dr. Smith for being here with us as our moderator this evening. Thank you very much. As many of you know, we host several events each month here. Most of them take place in this room as part of our Body, Mind, and Spirit calendar here at St. Leonard. Those are available on the front table and out in the lobby as well. And right on the table outside the door are flyers for all of the events that are upcoming in the next month or so. And we would love to have you at those events as well. Father Gene asked me to announce that if you miss one of the presentations, for instance, the one we had back when Chris Duncan was here a few months ago. Bob is filming for the Miami Valley Cable Council. They are running these presentations on their stations. So you can call them to see what the times are or go online, but they've run them several times. So he's filming tonight. Thank you, Bob, for doing that. And then you'll also, if you live at St. Leonard, get to watch it on our TV that goes into your homes as well. I'd like to introduce Dr. Mark Smith now. He teaches courses in American politics, constitutional law, and research methodology, data analysis. He's authored numerous refereed journal articles, book chapters, and other publications. His primary research interest is in the field of religion and American politics. Before joining the faculty at Cedarville, Dr. Smith taught at Tulane University and at Calvin College. Dr. Smith also serves as the director of the Center for Public Studies at Cedarville University. Thank you very much for being here.
It's good to be with you. I've spoken here a few times in the past. Always enjoy it, always enjoy the engagement that you have. It seems like I'm always asked to talk about the uncomfortable things, and so tonight is no exception. So the topic is the Supreme Court and political division. You know, what else do you need to say, right? Anybody have questions? No, I'm just kidding. The Supreme Court is obviously in the news a great deal, and it should be in the news a great deal. There's nothing wrong with that. But it's interesting, you know, the court by design is our least political branch of government. It's appointed by the president, it's confirmed by the Senate. There are no elections that they serve, there are no term limits that they have. They're designed to be removed from public opinion, removed from pressure. But almost by definition, they find themselves in the middle of a lot of controversies. When the court hands down a decision, it feels permanent at some level, even though it's not. It feels almost like it's final. You know, as George Norris said, the people can change Congress, but only God can change the Supreme Court. And I think that's the way we feel a lot of times when the court makes a decision, especially if we don't like it. But, you know, some of this is expected. The court is resolving some of our most fundamentally difficult issues, whether it's designed to or not. Abortion, marriage, gun rights, religious liberty, sexual orientation questions. These all come before the court on a regular basis. And so when they make a decision, roughly half the country is going to be upset about it. And that's not all that unusual. But if we're honest about it, a lot of what we've seen lately is kind of unusual. We've seen people demonstrating outside of Supreme Court justices' homes. We've seen threats of violence. We've seen people arrested threatening violence of Supreme Court members. We've been inundated with arguments about packing the court, about impeaching members of the court, about making them have term limits instead of lifetime appointments. Much of this recent debate really, of course, stems from the court's recent decision in Dobbs versus Jackson Women's Health, the 2022 decision that dealt with Roe versus Wade and Planned Parenthood versus Casey. This isn't any news to you all. Anyone who follows politics and follows the court knows exactly what happened there. But even in the Dobbs case itself, we see these divisions sort of come forward very clearly. In Justice Alito's majority opinion, as you see there on the screen, I'll read it out loud, he says the Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision. Pretty straightforward. The question that we're dealing with really isn't covered by the Constitution at all. He was able to command a majority of the court for this opinion. Chief Justice Roberts agreed with the court when it came to upholding the Mississippi law in the case, but disagreed with overturning Roe and Casey. And so he filed a concurring opinion, and he says the court's decision to overrule Roe and Casey is a serious jolt to the legal system, regardless of how you view those cases. A narrower decision would be markedly less unsettling, and nothing more is needed to decide this case. Chief Justice Roberts, whatever you think of him, has a deep and abiding concern for the legitimacy of the Supreme Court. He was concerned by overturning Roe and Casey that the court would ruin its credibility to some extent. And I think that motivated his opinion quite a lot. And of course, the dissenters gave us a different argument altogether. They say whatever the exact scope of the coming laws, they're talking about the state laws that are going to develop after this decision, one result of today's decision is certain: the curtailment of women's rights and their status as free and equal citizens. So, we've seen these three different points of view put forward in the Dobbs case, and they're just fundamentally in disagreement with each other. What's a right? What's not a right? What's the court's proper role? What's not the court's proper role? We see it all right there in this particular case. So what I want to talk about in light of this, three basic things. Two of them I think you'll expect. The Supreme Court is divided. Clearly it's divided. It's divided amongst itself. There's strong divisions on the court, and we're going to talk about those. It's also true, though, the Supreme Court is divisive in a way that has not been recently. The court is losing in the public opinion battle to some extent. People have a more negative view of the court now than they have in the past generation. But I'm also going to argue with you that the Supreme Court is more united than we think, and that there's more unity on the court because of the law, and there's more unity on the court because of the personalities of the court than we might expect. A great deal of the media coverage the court gets is because of controversy. But that doesn't mean all that the court does is controversial. And so we need to focus a little bit on where the unity exists and how it exists, and we'll do that. But let's jump into the division first. So why is the court divided? Well, I think the most obvious division on the court comes to the matter of interpretation. The court just simply disagrees amongst itself as to how to interpret the Constitution. There are two basic schools of thought, and these are sort of very broad, general statements. There's always complexity underneath the surface here. But originalism is one school of thought that I think right now a majority of the court basically embraces. The other school of thought is, we're going to call it living constitutionalism. Two different points of view, two different methods of interpretation lead to two different sets of outcomes. So let's talk about these a little bit. Let's look at some quotes here. This comes from Obergefell versus Hodges. That's, of course, the case where the court recognized the right of same-sex couples to marry. So 2015 decision. Justice Kennedy here, I think, gives us a very perfect encapsulation of the living constitutional approach. So he says, the nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all of its dimensions. And so they entrusted to future generations a charter protecting the right of all persons to enjoy liberty as we learn its meaning. When new insight reveals discord between the Constitution's central protections and a received legal stricture, a claim to liberty must be addressed. So what's he saying there? The Constitution has a certain set of principles, but as we evolve and as we change and we see conflict with those principles and what we think now, then we have to address it. This is, again, a good example of that living constitutional approach. In that same case, Chief Justice Roberts, in a dissenting opinion, gives us, I think, a very clear idea of the other point of view. He says, supporters of same-sex marriage have achieved considerable success persuading their fellow citizens through the democratic process to adopt their view. That ends today. 5 lawyers have closed the debate and enacted their own vision of marriage as a matter of constitutional law. Stealing this issue from the people will for many cast a cloud over same-sex marriage, making a dramatic social change that much more difficult to accept. So what's Roberts accusing the majority of here? Taking their own understanding of marriage, their own set of values about sexual orientation, and importing those into the Constitution. So there we see it. 2 divergent philosophies when it comes to interpreting the document. Now you have a handout, as Kelly said, and that handout, on one side of it at least, we're going to see a table that gets into some of these differences between this living constitutionalism on the one hand and originalism on the other. So we're looking at interpretive method, constitutional change, the role of history, how much discretion does a judge have, and then what's the basic view of the Constitution. We won't spend a lot of time on this, but I just want you to get a feel for these differences. So the originalist argument is essentially that those who wrote and enacted and first interpreted the Constitution, their understanding should be respected as we consider issues today. So the original meaning of the document, as we can unearth it historically, should be binding on us to some extent. The living constitutional approach is essentially that we develop meaning or authority based on contemporary values. So as society changes and we recognize those changing values, we take those and we interpret the text of the Constitution with those values. So the question isn't what does the word establishment mean to those who wrote it in 1787 or 1789, but what does it mean to us today? How should we think of establishment of religion in today's reality? That's sort of this living constitutional method. Now, originalism is often accused of being opposed to change. That's not accurate, I don't think. Their argument is if we're going to change the Constitution, it should be through amendments. We should go through the process, amend the document like it allows itself to be amended, and we see change through that. The living constitutional approach is much more open to change through interpretation. So an amendment isn't necessarily needed, but we update our understanding of the language of the document, and then we can change the document through that. So, I'm really biased here. I'm more of an originalist, but I want to try to give you a sense of both perspectives. A living constitutionalist might argue we don't need any language in the Constitution about the right to privacy. We all value privacy. Our society values privacy, so let's interpret the document as if a right to privacy is there. Living constitutional approach. An originalist would say there's nothing in the text about privacy. There's no protection for it. If you want it, let's amend the Constitution and we can put it there, but it doesn't exist. Just 2 very different methods. For the originalist, the role of history is authoritative. If they can unearth history and unearth the meaning of the text and figure out what the people meant when they wrote those words, that's going to be binding. So for them, history is an authority. For the living constitutionalist, history is useful. But if it runs into conflict with contemporary understandings, the contemporary understandings are going to prevail. So if they see history and it agrees with contemporary understandings, well, they can respect those things together. But if the history's on one side and contemporary values are on another, generally they're going to go with contemporary values. When it comes to what should judges actually do, what's the job of a judge? How much discretion do they have? The originalists would say the judge is bound by the text whether they like it or not. So I'll give you an example. The Supreme Court had to deal with the question of whether or not burning an American flag is protected free speech. Pretty controversial decision. Most of, but not all, most of the originalists on the court decided that it was indeed protected speech. But they also wrote opinions and talked publicly about how much they hated it. Like, we feel bound to reach this conclusion based on the language and based on the history of the document, but we don't like it. If you want to change this, you need to amend the Constitution and reach a different result in order to protect the flag. For the living constitutionalists, judges have much more latitude to use their values or society's values, and so there's much more, I think, I wouldn't say open-ended, that's not fair, but much more likelihood you'll see change through judicial discretion. So essentially, for the originalists, the Constitution is a fixed document. It's stable. It's predictable. For the living constitutionalists, the document is organic. It's evolutionary. It adapts. So, you know, if you believe in evolutionary theory, an organism adapts to its environment. That's how they see the Constitution. It adapts to its environment. As the world changes, the Constitution must change right along with it. Otherwise, they would say it becomes irrelevant. So right now in the court, I think there are 5.5 maybe originalists, depending on the issue. So 5.5 to 6 originalists, depending on how we count things. And there are 3 pretty firmly committed living constitutionalists. This is the first time in any of our lifetimes that the court has had a majority of people so strongly in the originalist position. We've not seen that before. So the court is also divided, and these things go together, but the court's also divided now because there's good evidence that it's voting in blocks. Court members are voting in blocks with each other. So they're voting more along an ideological dimension when they cast their votes when it comes to deciding cases. And again, some of that's related to the method that they're choosing, but not all of it. The other side of the table that you have in your hands is a bunch of numbers. And I apologize at one level, but there's really no good way to communicate this without numbers. You don't have to read all of them necessarily, but let's give a sense of what's going on here. So what these numbers look at is how often the justices vote with another justice. And what percentage of the cases are they voting with this other person? So when we look at Roberts, Chief Justice Roberts, and you read his numbers across, how often is he voting with Justice Sotomayor? Well, 36% of the time. Yeah, those are percentages, yep. How often is he voting with Justice Kavanaugh? 96% of the time. Kavanaugh and Roberts are together when it comes to non-unanimous cases. Well, Roberts is fairly moderate on the court, so these numbers make some sense, I think. But let's look at someone like Justice Thomas, a little more conservative, let's say. He only agrees with Chief Justice Roberts 62% of the time. But look at Justice Sotomayor. Only 13% of the time do Thomas and Sotomayor line up on the same side of a case if it's not a unanimous verdict. Well, look at Justice Sotomayor. You know, she only agrees with Alito 13% of the time, Thomas 13% of the time, relatively low numbers. Justice Barrett, she only agrees with her 24% of the time. I think when you look at these numbers, you see the court basically has 3 blocks. It has a pretty conservative block with Justice Thomas and Justice Alito. It has a pretty liberal block. This is the term before this one, because we don't have data for this term yet because it's not completed. The liberal block here was Breyer, Kagan, and Sotomayor. Justice Jackson, the new justice, will be sliding into that Breyer slot, I think. She'll probably be pretty progressive. And then I think there's a fairly moderate group with Roberts, with Gorsuch, with Barrett, and with Kavanaugh. Now, we haven't seen enough decisions out of Gorsuch, Barrett, and Kavanaugh, I think, arguably, to know fully well what we're getting into. But they appear to be a little bit more moderate than Alito and Thomas, but certainly far more conservative than the liberal wing of the court. So, court's divided along ideological grounds as well as interpretive methods. So let's keep moving on here. The Supreme Court is also divisive. And just to be short about it, the court has a public opinion problem. So this is a figure, the level of trust and confidence that people have in the court, according to Gallup polling. And you've seen that number decline fairly significantly since the mid-1990s through to today. Now, to be fair, almost all of our institutions have seen a similar decline. Presidency, Congress has always been pretty low, but presidency's declined. The news media has declined. The educational industry has declined. The only institution that hasn't seen this kind of decline is really the military when it comes to how people trust this institution. And so the court has suffered in public opinion. Now, at one level you might go, who cares? Who cares that people don't like the court? It matters because the court has no power. In the sense the court can't enforce its own laws. There's no court police force. There's no court army connected to them. There's nothing like that. They rely on trust and credibility to be believable and to function. And if significant parts of our population no longer trust the court, at some level they no longer trust the law. And that's a significant issue. Now, I think you could argue our parties have driven some of this. Both parties have driven some of this. But if we see an erosion in public trust of the court, I think we're entering into potentially a fairly dark phase of American political history. The rule of law largely depends upon our ability to have confidence and trust in the legal system. And if that's starting to dip, then I think we're going to see some changes, potentially some very bad ones. The court is also divisive, I should say, because it has a really fractured and contentious nomination process. Somebody guess, how many votes to confirm do you think Justice Scalia got? So out of 100 votes in the Senate, how many votes do you think he got when he was being nominated to the Supreme Court? Anybody want to guess? 92. Here, 90, 92. He got 98. He got 98 votes when he was confirmed by the United States Senate. Now, Justice Scalia, extremely conservative. In some ways, one of the founding fathers of originalism, got 98 votes. I want to say that was 1986, something like that, 86, 87 at the latest. What about Justice Ruth Bader Ginsburg? 96 out of 100 votes. Justice Ruth Bader Ginsburg. Justice Alito, 58 votes. Justice Gorsuch, 54 votes. Justice Kagan, 63 votes. Brett Kavanaugh, 50 votes. Amy Coney Barrett, 52 votes. Ketanji Brown Jackson, 53 votes. So what we've seen is a changing nomination process where our view of nominations has become much more contentious and much more divisive. So there are a lot of questions about why this has happened. And we can talk about that, and you can ask questions about it for sure. But just to show you some numbers here, from 1967 to 2000, for all nominations, and that includes some failed nominations in there, the average justice got almost 77 votes in the Senate. Since 2000, that number's gone down to 59.5. And so the number of votes of support have gone down dramatically. Now, I think there are some clear reasons for this. But I think mostly it's because the court has been involved in the culture war. When it starts making decisions about abortion and gay rights and things like that, and the parties begin to polarize on those issues, then Supreme Court appointments become significant political events. Senators can make a career off of questioning a Supreme Court nominee, much less raise millions of dollars in how they question a Supreme Court nominee. They also have almost no incentive to vote for them if you're in the other party. What does it benefit you as a Republican to vote to support a Democratic nominee to the court, even if you think they're qualified? All it's going to do is cause you grief. It's going to cause you to be challenged in a nomination. It's going to make getting reelected harder. And so even if you think you should vote for this person, you don't have a good reason to do it necessarily. Now, again, I'm really biased, and I'm hopefully open about those biases. I think most of this started when Democrats in the Senate decided to play hardball with Republican nominees during the Reagan and Bush administrations. So Judge Bork, extraordinarily qualified candidate, fails to get confirmed. Clarence Thomas, I would say an extraordinarily qualified candidate, struggles to get confirmed, primarily in both of those cases because of the abortion issue. And so once Democrats began to play hardball over nominations, then it just became almost a matter of course, and now both sides are treating this like it's Armageddon every time we have a justice get nominated, which is, I think, unfortunate. So why is the court more unified than you might think? The Supreme Court is an appellate court for the most part. It does have some cases that it hears originally, but the Supreme Court's an appellate court. So it takes cases on appeal from lower courts, either state Supreme Courts or federal appellate courts. It only chooses cases when there's division involved in the circuit courts below them, or when a state has made a significant mistake. It's rarely choosing cases that are easy and that have already been resolved at the lower level of the judicial system. So, almost by design, the court is taking difficult and divisive cases because it has to. And so I think a lot of us just assume the court's divided because we only hear about them settling controversial cases. If it's not controversial, the Supreme Court's not settling it. Lower courts are going to settle it, and you're never going to hear about it. But when we hear about it from the court's perspective, well, it seems all that divisive and controversial. Yes, it is, but that's because it's a unique case, a difficult case, maybe a hard set of facts, maybe a new issue that they haven't resolved yet. And so it appears to be, I think, more divisive than it actually is. And so the court sets its own agenda. It chooses to take difficult cases. Otherwise, it doesn't bother wasting their time on a case. So again, I think they're a little bit more unified than you might expect. It's also true, and we won't spend a lot of time talking about it, and this is one thing I really try to communicate to my students, is underneath the divisions on the court, the divisions on the court, I think, when it comes to a body of law, like speech, the divisions are the tip of the iceberg. But the iceberg underneath the surface of the water, there's a lot of unity. So think about something controversial like freedom of speech. They are going to disagree over certain things. They're going to argue about, in a certain moment, at a certain school, in a certain event, whether this person can be punished for this particular kind of speech. But they have fundamental agreements that exist that are beneath that decision. The Supreme Court unanimously believes that advocacy is almost always protected in all situations, regardless of the setting. Unanimous decision, Brandenburg versus Ohio, 1969 decision, where the court decided unless the speech is going to create imminent lawlessness, it's protected. It might be political, it might be ugly, it might be hateful, it might even be preaching for the overthrow of the government of the United States of America. But that's protected speech, and I can guarantee you all of the justices in the court would agree that that's protected speech. And so when a case comes up that deals with protected speech and it involves that issue, well, a lower court settles it. The court doesn't have to deal with it. Well, when it comes up in a different setting, where we're in a school system, for example, and it isn't so clear what the student might be saying, or it's a public setting, they're going to fracture a little bit on the margins. But underneath those margins, there are wide bodies of agreement. And I think if you don't study the Constitution, the way the court treats the Constitution, we can get lost in the disagreements without recognizing the fundamental protections that exist in civil liberties. Think of something even like free exercise of religion. Controversial, divisive at some level. But virtually everyone agrees that free exercise, when it comes into the context of worship and religious activity, is universally protected unless it's destructive and dangerous. That's it. And so we have broad protections for the free exercise of religion, but they might disagree on the margins about whether a church can get reimbursed, for example, when it applies to the state for expenses related to refinishing a playground. They might disagree about that, but they're not going to disagree about the fundamental nature of the church, the freedom of worship that goes on there, and how those people have basic liberties in the process of worship. And so, yes, there's disagreement over liberties, but those disagreements, I think, often cover over fundamental principles that all the justices would adhere to. I think there's one other area where the justices have a great deal more unity than you expect, and it's because the justices actually care about each other. I think we perceive them as being at each other's throats, as fighting and controversial and battling one another all the time. The evidence is that that's just not the case. Let me show you a couple of pictures and tell you a couple of quick stories about this. So this is Justice Sotomayor and Justice Thomas. Again, as I was showing you, they disagree more than anyone else in the court. Justice Thomas came under a tremendous amount of criticism because of the Dobbs decision. He wrote some pretty radical things and parts of a concurring opinion there. He got a great deal of pushback because of it. Justice Sotomayor, not long after, was giving a public talk at a law school and was asked about relationships on the court. And I want to read you a couple of quotes that she said about Justice Thomas. She said, "He is a man who cares deeply about the court as an institution. Justice Thomas is the one justice in the building that literally knows every employee's name, every one of them. And not only does he know their names, he remembers their families' names and histories. He's the first one who will go up to someone when you're walking with him and say, 'Is your son okay? How's your daughter doing in college?' He's the first one that when my stepfather died sent me flowers in Florida." And so Sotomayor talked about how she disagrees with Thomas on so many legal issues, but as a human being, they get along well, they enjoy each other's company, and they have a tremendous amount of respect for each other. Of course, maybe most famously, this is Justice Scalia and Justice Ginsburg on vacation together. So, again, fundamentally different views of the law. Their families were very famous, long-life friends. They traveled together. They went to the opera together. They did lots of activities together. They rang in the new year together, typically. Very, very close connections between them. When he was asked about his opinion of Justice Ginsburg, about whether or not he liked her, Justice Scalia said, "What's not to like? Except her views of the law." One of my favorite story about those two, Judge Jeffrey Sutton, he was a clerk for Justice Scalia, is now a federal judge, was visiting Scalia in his chambers, and he saw that Scalia had 24 roses that he had ordered for Justice Ginsburg's birthday. And Sutton said, "What good have all these roses done for you?" This is Sutton's own telling of the story. "Name one 5-4 case of any significance where you got one Justice Ginsburg vote." Justice Scalia's response was, "Some things are more important than votes." And he's right. Some things are more important than votes. You know, I think the court, as divided as it is, as divisive as it is, and as controversial as it is actually a pretty good model for what politics ought to look like in a democratic society. They come together, they argue with each other, they write opinions back and forth, they publish their outcomes. That's it. And they can still be friends, they can still be civil, they can still function together. And so as much as we like to think of the division in the court, I think we should give a little bit more credit to the unity that's there as well. All right, those are my comments. Questions, let's take questions. Should Supreme Court justices have term limits? How many of you would say you think they should have term limits? Okay, so it looks like a majority of you. I don't know if I'm not opposed to the Supreme Court having term limits, honestly. I think the lifetime appointment is there for two reasons. One, it's there primarily to give them enough time to develop expertise, because the federal law, much less the Constitution, is voluminous. And so it takes something of a lifetime to learn enough to be a good justice on the court. So I think in that sense it makes sense. It's also there to give security to people who are extraordinarily talented and who could make a lot of money in the private world. It gives them a lifetime of security and benefits, even though it may not give them the salary they could win outside of the court. And so I think the lifetime appointment is reasonable, but I don't think term limits are necessarily a bad idea myself. If it were a term, I would say it would probably need to be a long one, 12 to 15 years or 18 years maybe I've seen thrown around. I think that would probably be reasonable. And I think as a reform, I'd much rather see term limits than something like packing the court or tripling the size of the court or doing something like that. And so I think it's a reasonable reform. Can a judge be impeached? Yes. And the process is just like it is for any other federal official. So members of the court can be impeached just like the president or vice president or secretary of fill in the blank. It's same thing. The House drafts articles of impeachment. The Senate holds a trial. The difference is in the impeachment of the president, when that goes to trial, the Chief Justice sits in that trial and presides over it. Obviously, if it's not the president being impeached, the Chief Justice doesn't have that function. But besides that, they're really identical processes. So the Senate could convict a justice and could remove them from office, just like they can any other federal official. It's only been threatened. It's frequently threatened, but rarely attempted. And so, the South was littered with impeach Earl Warren signs for about 20 years after Brown versus the Board of Education. But we've only seen a couple of justices actually go through the process of impeachment. That's very early in our history, and it wasn't successful. So we haven't seen much of a precedent there. I think this is a really good question. I think an important question. Is there enough diversity on the Supreme Court? 7 out of 9 justices are Catholics. Is that a problem? So I think a really good question. I'm, again, very, very biased. I think the biggest issue for me when it comes to diversity in the court is that they're overwhelmingly from like Harvard and Yale. Justice Barrett's the first justice from Notre Dame. I think Justice O'Connor was from Stanford, if I recall correctly. But overwhelmingly, the justices come from Harvard and Yale and maybe Columbia, and that's about it. And so I think we need a little bit more institutional diversity on the court from other law schools being represented there. Just to be very honest with you, I'm not much of an identity politics person. I don't know if I care of what color anyone is or what racial background or anything else they are. I'm more curious in intellectual diversity, and I think that would benefit the court to have a little bit more of that. Religion is interesting, though. Historically, the court's been overwhelmingly Protestant. In recent history, that's not the case at all, as the question notes. But as you see, even there's a good bit of division within the Catholics on the court. It isn't as if they all vote as a block, because that's just simply not true. So it's a really good question. The card has one other question that I think is interesting as well. Does the Federalist Society have too much influence on the justices in the court? or on the selection of justices. You know, the Federalist Society has been an extraordinarily successful group in terms of mainstreaming originalist jurisprudence on the court. Essentially, I don't know the numbers, essentially every law school has a Federalist Society chapter. And so you have a conservative element in a lot of law schools because of that Federalist Society chapter. But it was, and again, I could be wrong, but I think it was really only during the Trump presidency that it had such a significant effect on choosing justices. I'm not sure that's going to be the case in future administrations, even if they're Republican, but I could be wrong. So I'm not overly worried about that, but again, I'm very, very biased. This question, another great question, is the confirmation process broken with the Senate hearings being just partisan sideshows? Yes. Next question. No, the next question is, what changes would you recommend? The change I would recommend that will never happen is that there should be no cameras there. A lot of what you see is just people mugging for cameras for fundraising purposes and making speeches for fundraising purposes. I think taking cameras out of that process would help a lot. So, but it's never going to happen. It's just not. It's too powerful of a tool for members of the Senate to want to give it up. So I would be all in favor of it, but it's not going to happen. Just in case you're interested, at one point they've talked about putting cameras in the Supreme Court for to record, so they could broadcast just like C-SPAN or whatever. There was a hearing where Justice Souter, no longer in the court, but Justice Souter was asked about that. And Justice Souter's response was, "Over my dead body." And he wasn't kidding. He was just, and I think that's most of the justices. They have no interest in having anything recorded, or at least as little recorded as possible. Why does the court use the term women's rights when addressing abortions? 23 chromosomes from women, 23 from male. Where are the men's rights? It's a fair question. Again, I'm very biased. It's a fair question. I will just casually note, as long as the men have responsibility, then I would talk about their rights. That isn't always seen as going hand in hand. Generally, the court, pro-choice members of the court, have seen abortion as an issue of female equality. I'm not defending that position, but just when you read Justice Ginsburg and some of the other justices who had a very strong position on abortion, they viewed it as the right to choose was inherent for women to be equal in the workforce and for women to be equal in society. And so they purely saw it through that feminine perspective. I'm not sure that's the right approach to it, but I understand where they're coming from. Should Justice Thomas be impeached? You guys give me all the easy questions. So if you haven't been paying attention to the news lately, Justice Thomas, and here's another question about that, so I can remove that one. Justice Thomas, it's recently been publicized that he accepted some extraordinarily expensive trips from Harlan Crow, who's a billionaire, a conservative billionaire semi-activist. He funds a good bit of political activity, and Justice Thomas accepted trips from him, I would guess collectively into the millions and millions of dollars when we look at a total amount of money or amount of cost. Yeah, I mean, that's the issue is the expectation is that would be disclosed. Justices need to disclose a gift. And I think he disclosed the first kind of thing like that, and he hasn't disclosed anything since. And so, yeah, it looks really awful. It looks awful, frankly. It just looks terrible. And it has the appearance of bad ethics. It just looks like bad ethics. I don't know if we have any evidence that it affected anything, but boy, it sure looks really awful. Is that enough to impeach him? You know, I think that would be a reasonable discussion. You know, I tend to appreciate Justice Thomas, and I don't always agree with him, but I think that would be a reasonable discussion, frankly. I mean, it just looks really poor. Now, you know, his point is, this is just a friend of mine. He doesn't have business in front of the court. But, you know, he has a strong interest in conservative outcomes at the court, which is really what we're talking about here. And so it just really doesn't look good at all. Yeah, it's a sad day. Any member of the court is found in a position like this. I think it would be defensible to talk about it. I think they need to update the ethics requirements for the court. They need to update the ethics requirements for Congress as well. So, you know, I was always under the assumption that you went into public service for the public and not to get rich. And boy, it just seems like so many members of Congress make a lot of money. And it's unfortunate. So I always think of Harry Truman. When he went into public office, lived in a very modest, simple home, and when he left, he retired into that home. He always turned down opportunities to make money. He didn't serve on boards or anything like that. He didn't go around giving $1 million speeches. He did sell his memoirs, which he did do. He made a little bit of money off of his memoirs. But he always argued his point wasn't to get rich, it was just to serve the people. I think that's the right attitude. So we could use more of that. Could you comment on the right to carry a gun and how that could be, and if that could be restricted? The Second Amendment, so I have a pretty heterodox view of the Second Amendment compared to a lot of people that I generally agree with a lot. I view the Bill of Rights as primarily written to restrict to restrict the federal government. So when you look at the First Amendment, it starts with Congress shall make no law. I think the Bill of Rights were really written as a bar to federal government. The purpose of the Second Amendment, I believe, was to allow the states to have a militia system without federal intervention. So I think states have more latitude to restrict firearms if they choose to do that. Now, we could argue about what's good policy or bad policy, but I don't see the Constitution as being a huge bar against states restricting firearms. I would probably come down on only having sort of a very modest view of self-defense within the home sort of purpose there. Carry, open carry, constitutional carry, I don't think those are mandated at all by the Constitution. And if states choose to restrict them, they can restrict them. Justice Scalia, Justice Scalia wrote the DC versus Heller case, which is the one that really gives us the Second Amendment protections in a modern sense. And in that decision, he argues, this doesn't give you a right to own a bazooka. It doesn't give you a right to own anything you want to own. It simply recognizes a right of self-defense within a home function. The rest is sort of open to regulation. And so again, this is a very conservative person making this kind of an argument. I think on the Constitution, he's right. Justice Stevens, who argued very famously in Heller, as well as in the McDonald case that deals with state governments, argues that really states should be able to do whatever they want with firearms, including banning them if they choose to do that. I'm not sure I would go that far, but he can make a defensible argument. The text of the document allows him to make that argument. So it's a really good question. Please address the state's right to nullify opinions of the Supreme Court if the opinion is not constitutionally based. I don't think such a right exists. I don't think states have the power to nullify Supreme Court opinions, even if they don't agree with them, even if the state believes they're not constitutionally based. It may not be popular, but those are the exact same arguments that Southern segregation governors were making during the 1950s and 60s to nullify federal law and federal decisions so that they did not have to segregate and did not have to follow federal law like the Civil Rights Act and the Voting Rights Act. I think we go down a very dark path when we think state and local governments can defy the federal government. As much as it might please us, and as much as we might disagree with the court and with the decision and with even a federal law, I think back to Abraham Lincoln as he was dealing with the Dred Scott decision. So this is before Lincoln's president. He's having arguments with Judge Douglas about the Lincoln-Douglas debates were famously about these questions of civil rights, the role of the court, the federal system, and everything else. And Dred Scott's handed down, and Lincoln's forced to react to this. How do you deal with the court making a horrific decision that Dred Scott doesn't have citizenship, doesn't have standing in a federal court, and they even challenge, I think, to an extent, the citizenship of all African Americans in that case. It's a horrific decision. And Lincoln's argument, which I will hold to, was that we can try to change the decision. There's a system in place to change that decision. We can amend the Constitution. We can impeach justices. We can rewrite federal law. We can do a lot of things within the system and still obey the court. So we don't have to agree with the court, but there's a system that we'd use to deal with our disagreements. The alternative, frankly, is chaos. The alternative is chaos. And we're getting ready to run into it. Because the state of Georgia will pass a law about abortion, and the city of Atlanta is going to say no thanks. Come and enforce it. State of Ohio might pass a law about abortion, and then Cleveland's going to say, let's see. Well, if the federal government passes a law about abortion, does that give Ohio the right to say, no thanks? I mean, as much as you might disagree with a federal decision or a decision of a government above you, put the shoe on the other foot. Are you comfortable with the other side having the power to disagree with a federal law that you agree with? I don't think any of us want to be in the position where state governments and local governments can simply decide what the law is. Again, I think that's a dark place that could lead to a lot of destruction of our rights and liberties. And so when the court does something, or when Congress does something, or the governor does something, I think we use the system to change that. If you don't, you're talking about burning down the system. And I'm just not there. I know there are people who are there and who argue we need to burn the whole thing down. I think if you burn it down, you have no idea what that's going to look like, much less what's going to replace it. And so I'm not ready to go there. I've had a lot of good faith arguments with people who disagree with me on that, but I think the Constitution's valuable, and I think the Constitution teaches the supremacy of the Constitution itself. And when laws are made and decisions are made under the powers of the Constitution, they're binding, whether we like it or not. And so I think that's the way it has to be. Now, again, I know not everyone likes that, but I think that's the way it goes. Okay, this is a good question. This is a more practical question. We read of the final written opinions of the court, but how do they deliberate? What's the process? How do they argue prior to writing? So the justices, first of all, some of this is just unknown because they don't talk about it and they forbid their clerks from talking a lot about it. We know basically how it functions. After they hear oral arguments in a case, they have a judicial conference where all the members of the court go to their own private area. There's no clerk, no administrative assistants, it's just the justices. And the Chief Justice will lead a tally of the vote. And so the chief will say, here's how I would vote on this case. And then they'll go in order of seniority, from the most senior justice all the way down to the least senior justice. And the chief at that point will have a sense of what the vote looks like. If the Chief Justice is in the majority, he'll assign the opinion in the majority. If the Chief Justice is not in the majority, the most senior member of the majority will assign the opinion for the majority. That majority opinion that's written is then circulated to all the justices, and they can respond to that. They can argue with each other at that point. They can trade memoranda back and forth. You might write your own opinion and say, you know what, I think this is a better approach. Here's my approach to this whole thing. It can be very formal. It can be very informal. It can even cause votes to change. Sometimes majority opinion goes around and people go, you know, I'm not sure I like that. I can't vote with that. I got to change sides. And sometimes that 5-4 decision in one direction becomes 5-4 in the other direction. So there's a good bit of politicking that occurs and persuasion that occurs from that initial tally to the final outcome. What we know for sure is all the opinions are circulated. So the majority opinion, concurring opinion, dissenting opinions, those are all circulated amongst the justices, and they can react to those. And you even see in the opinions themselves, they're reacting to each other's opinions. So in the majority opinion, in Dobbs, for example, Justice Alito responds to the dissent because he's already seen it. He's seen it before, he's finished his majority opinion, he responds to it, and the dissent's responding to the majority opinion, and so you see they've seen everything and they're reacting from that perspective. So we know that much, which is a good bit, but we don't really know necessarily, you know, are they calling a meeting? Are they showing up in someone's office and having a sit down to talk about something? Is this coffee? Does this look a little more heated sometimes? There are a lot of rumors that we hear about certain instances where justices have changed their mind. It's gotten argumentative and destructive, but those are rumors. Unless we're talking about leaking an opinion, which happened, of course, with Dobbs, we really don't know a lot about how the court functions at that level because they want to keep it private. And I think that's perfectly appropriate. So anyway, thank you very much for your time this evening. Always a joy to be with you, and I'll see you again soon.